When are educators required to report suspicions of child abuse and neglect as mandatory reporters? Are unsubstantiated rumors enough to create a reasonable suspicion of child abuse? Jamie, have you seen my soapbox? I think I'm going to need it today.
Dude, you should just carry that thing around with you.
These days, I pretty much do.
I know, you use it enough. So this is a fascinating case for all you educators out there, especially the teachers. This is the kind of thing that anyone in schools could very easily have to confront. This is the case of a school counselor who was told by a student about a possible inappropriate relationship between a teacher and another student, and that counselor didn't report it. Well, some more things came to light. She got fired, she filed a lawsuit, and the court had some interesting things to say about it all.
Yeah, there's a reason I need my soapbox.
Yes, exactly. So there's a lot of important points in this case that educators really need to think about. So today, we are covering Small versus, Streater Township. Yeah. Is that what it is? Streater Township High School District. That's the one. Welcome to Chalk and Gavel, everybody, where we explore how the law shapes education, one case at a time. I'm Jamie Cudlitz. I'm a former middle school math teacher and principal.
And I'm Chris Thomas. I've been a high school English teacher and a school attorney. Now we're both professors of educational leadership, bringing you the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
Okay, welcome back, everybody. Again, we're in the fall. The Education Law Association's annual conference is coming up in Kansas City, November 5th through 8th, 2025. We definitely wanted to tell everybody about it. It's a great organization. Chris and I both have been involved in this one for years. It's where we met. Yeah. It's where we came up with the idea of Chalk and Gavel. Yeah. So if you want to hear more about that great organization, great conference, go to educationlaw.org and you can check everything out there. You can register for the conference if you want to come see us and hang out with a lot of people who are really interested in and passionate about education law. We're going to do some Chalk and Gavel sessions there. One of them we're thinking about doing is a Q&A. So if you want to send us your questions and we will answer them on an episode that we'll record at the conference, you can do that. You can do it through our website. You can send us information on our feedback form. You can send us an email, chalkandgavel@gmail.com. It's chalk, A-N-D, gavel @gmail.com. And yeah, we would love to hear from you.
We would also love it if you would like, rate, review Chalk and Gavel wherever you get your podcasts, and spread the word about the show. Tell a friend, use it in your professional development, in your classes, whatever you want. We've got a teaching guide on chalkandgavel.com. You can find us on our socials at Chalk and Gavel. We'd love to hear from you. And if you really love what you hear, you can find us on Patreon at patreon.com/chalkandgavel. For just $2 a month, you can help support this show as we continue to provide the education law content that you know and love.
It sounds good. All right. What's our bell ringer today, sir?
I'm really excited for this one. This is a weird one, and it's a weird one with some really interesting implications, I think. It's not a claim that I think I've heard before. So this is a case out of Virginia. It's Virginia State Conference of the NAACP versus County School Board of Shenandoah County. That's the case name. So it involves a school district who decided to change the names of two of its schools in 2020. So the schools were originally named Stonewall Jackson High School and Ashby Lee Elementary School. So those are all Confederate generals. And so after the murder of George Floyd and the Black Lives Matter movement, the school decided to change the names. And so they changed the names of the high school to Mountain View High School, and the elementary became Honey Run Elementary School. But here's where the fun starts. In 2024, they decided to change the names back.
Okay.
So in a 5-1 decision, the school board reinstated the names of the Confederate generals to the schools. And according to the court, like there was a ton of dialogue about this. Like they weren't shy about why they were doing this, right? And so, according to the court, quote, the record indicates that the highly symbolic name Stonewall Jackson was selected to convey a message or messages, such as signaling that the 2020 school board's efforts to condemn racism were counterproductive. So like there's a message built into all of this. And so after the school board changed the names back, a group of students and organizations sued the school board, arguing that the name change violated the First Amendment, violated the 14th Amendment's Equal Protection Clause, violated Title VI of the Civil Rights Act by creating like a racially hostile environment, racial discrimination, and the Equal Educational Opportunities Act. So they have this whole litany of potential violations here based on the name change. Well, the court issued a decision on September 9th of this year, so just recently, and the federal district court granted summary judgment to the students on their First Amendment claim.
Really?
Yeah. The students were arguing that by renaming the school Stonewall Jackson, and because the students were required to wear that on their jerseys and like their other uniforms for school activities, the mascot was also the general. So like they were the Stonewall Jackson Generals. And the students said that by forcing them to wear that on their uniforms,
it's compelling, like discriminatory speech.
It was compelled speech. Yeah. So they were basically like, the students were saying that you were essentially turning us, the students, into billboards for the ideological message that the school board wanted to send. And so they brought this compelled speech claim.
Fascinating.
It is. And it won. And that's like,
wow,
I
really?
know. It's I think it's a novel claim, and it has a lot of really interesting
It's incredibly, and part of me is thinking like, would the claim have held water if they hadn't changed the name in the first place?
And I don't think it would.
I don't think it would have either.
It's the message that they're conveying
changing it back. Yeah.
By changing it back. Right.
Yeah.
And so the court said like requiring students to wear Stonewall Jackson Generals on their uniforms violated their First Amendment rights to be free from compelled governmental speech. Yeah. So like it raises so many fun questions. Like, does that mean you can't name a school after anybody? Because, what if you named like Rosa Parks High School, right? Like you named that because you want to, either celebrate her life or because, you're taking a stance on civil rights. Like, does that also have implications for students' compelled speech? And this makes me think of Evan versus Hawes. The compelled curricular speech one where the student had to give that like dramatic monologue, right?
Right.
And she argued that it was compelled speech.
Right.
In violation of her First Amendment rights. And so like, I think this idea of compelled speech, we see it in the student pronoun cases as well. Like compelled speech is such a like contested terrain right now. And I like this just kind of shows like, where is that going to take us as we think about that balance between students' speech, school speech, and when and what people are allowed or required to say. So I wanted to bring this because I think it's a really interesting one to watch. So we'll watch and see if it gets appealed.
Crazy. Well, I'm sure it will.
Yeah. Well, the other claims are going to trial, I think, because they didn't grant summary judgment on the other claims. So there's still a bunch of claims sitting around. But yeah, I'll keep an eye on that one because it's interesting.
Wow. Yeah, totally. Wow. Really cool. Okay. Thanks for that bell ringer, Chris. Nice. All right. Let's talk about this case involving mandated reporting kinds of scenarios, requirements, things like that. This is a big topic, man. Like
it is.
We are all, as we know, as most of us know, in schools, we are all mandated reporters, which means if we suspect some kind of abuse or something like that, we are obligated by law, I would assume in every single state in this country.
I don't know that for a fact, but
I don't know that for a fact, but I would think so. These are state mandatory reporting laws or state laws. Mm-hmm. So every state has them, and they're all, I'm guessing every state has them.
The ones I'm aware of are all very similar.
They're all very
basically
similar.
Like, if you work with kiddos, if you're an educator, like
whether you're a teacher, a counselor, cafeteria worker, if you work with kids in a building with kids, you are considered a mandated reporter.
And the question comes in, when does that mandate kick in? Right?
Exactly.
And most statutes they talk about reasonableness, and
we'll
talk about it, right?
We've talked about how reasonableness is one of those squishy legal terms that's very subjective. We've talked about it in most of our episodes. I think it's come up quite a bit. So there's
it has.
Sorry, folks, there's a reasonableness standard in this episode too. So all right, so let's get into it. So we've got a guidance counselor, in the Streater Township High School District. In 2004, this guidance counselor was hired. Okay, her name was Lisa Small. And at some point between 2004 and 2015 or so, Lisa got tenure under Illinois law. Okay, so this township high school district is in Illinois. And so just a real, there's a lot of states that don't do tenure anymore for teachers, but just a real quick recap. Tenure is essentially an expectation of continued employment year over year. So most teachers just get a year-to-year contract. They get a contract for the year, and then they get, in the spring, they get another one for the following year. And there's no expectation that they will legally at least have this job indefinitely, unless there's some sort of egregious kind of breach of contract, breach of law, whatever. So she got tenure. So there's this expectation of sort of continued employment.
Which comes with additional protections about like when and how you can end her employment.
Yeah, there's a lot more due process involved generally, things like that. So like I said, there's a lot of states that don't do tenure for K-12 teachers anymore. There's a lot of higher ed institutions that are trying to phase it out as well. So that's tenure, but that's not a huge part of the storyline here. So Small gets tenure. Something happened in her 11th year at that school. Okay, so 2014, 2015-ish. Up until that point, she's pretty much got a clean record. Okay. Never been disciplined, never poor performance annual evaluations, things like that. But on September 15th, 2015, Small was fired.
Oh. Okay.
Yeah. So again, prior to the 15th, nothing negative.
What happened in 2015?
Well, I will tell you. Thank you for asking.
Oh, good. I was worried that was the end of the episode. And your homework is to like and rate and review Chuck and Gavel.
So all of this stuff started in December 2014. So we've got student A, which is what the court called him, but let's go ahead and call him Anthony, just to make things simpler.
I like that. I like that.
You like that?
Yeah. No, we should give them names because initials are really tough.
Yeah. Okay. So student A is Anthony. Anthony came to Miss Small's office, the guidance counselor, Lisa Small. And during that meeting between Small and Anthony told her about a situation involving another student the court identifies as student B. So let's just go ahead and call her B because B is a name.
Oh, yeah.
B-E-A.
Yeah, no, that works.
Excellent. So we've got Anthony, guidance counselor Small, and B. All right. So Anthony's meeting with Small and tells Small about B.
Okay.
So Anthony tells Small that B had a, quote, inappropriate relationship with a teacher. Okay. The teacher's initials, according to the court, are RV. So how did Anthony know this information? Well, apparently B told him at some point earlier in that month, December, B told Anthony about her relationship with RV. Okay. They had multiple conversations about it until Anthony asked B's permission to tell somebody at the school about the situation. B agreed, but she said that she didn't want to tell someone herself because she was worried about getting in trouble.
Okay. Yeah. Okay. So there's a friendship here between Anthony and B.
Yep.
B shares the situation and Anthony is going to go try to
help her.
Yeah.
Right. But she doesn't want to, like, she's nervous. B's nervous, doesn't want to kind of ruffle feathers herself, but she is uncomfortable enough, apparently, with the situation that she tells a friend and essentially gives permission for that friend to tell somebody in authority.
Right. And you can, we haven't talked about what the situation is, but like you can understand where B's coming from, right? Like
I think so.
The power dynamics and all the potential issues here.
It's confusing. And remember, like these kids are high school, right? Like this is confusing. It can be confusing for adults, but to be a kid in one of those sort of power dynamic kinds of situations, that can be really tough, which is one of the reasons why we have all these kinds of protections for kids.
Which is kind of the justification for the mandatory
statutes. Exactly. So here are the details. So Anthony told Small that B and RV had sexted the previous school year. Okay. He reported that RV had sent inappropriate messages and nude pictures to B, and B had reciprocated and sent similar messages to RV as well. Okay. So there's sexting with inappropriate messages and pictures going back and forth. Okay.
Okay. And I think at this point, B is 17. So like,
yeah,
you can see why she might be worried about getting in trouble because like, that could be child pornography. Like there's so many things there for B that have implications. But like, you know, if you're looking at it from the teacher, like RV, like totally inappropriate, right? Like if
I mean, hands down, no question.
Right.
But yeah, like B participated in these messages going back and forth and sent nude pictures of herself and everything. So yeah, I could totally see why she's embarrassed. She doesn't, you know, there's aspects, you know, I'm sure that she has parts of her that are like, I don't want this to come to light because I could get in trouble and all that stuff. Anyway, so during that meeting between Anthony and Small, Anthony talked about his own experiences with RV. And Anthony apparently didn't like RV, you know, for reasons like, I think RV, you know, he felt like RV treated him unfairly. He got kicked out of class once or whatever. So, you know, Anthony's not a fan of RV. Okay. So this meeting is like 15, 20 minutes long. At the end of the session, Small told Anthony that she needed firsthand information about the situation. And so she asked Anthony to have B come talk to her directly. So, all right. Here, red flag
my
number one.
Soapbox out.
Right.
So you see this a lot in these sorts of situations where people think they need like proof or they need firsthand knowledge. Or firsthand information about this stuff. And that is just not
spoiler
the requirement.
Alert. You don't.
Yeah, you don't.
When it comes to the other stuff that we deal with on this show, like searches, and you don't need hard, concrete evidence. You need reasonable suspicion. And this is not necessarily any different.
Right. And like with the mandatory reporter laws and so many of these other protections for students against like sexual harassment and abuse, like the obligation to report triggers independent of like the obligation to investigate. So like, it's a question of like, you got to report it based on what you know. But like, if what you know isn't enough to like investigate, like that's someone else's job to do after you report it.
Right. And there are protections. Often there are protections built into the system that are designed to, protect, for lack of a better word.
Hey, there you go.
Somebody reporting, like it's not a question of the only way you can report something is if you have proof that it happens, right?
That's not the job of the reporter.
No, the job of the reporter is to report what they hear, what they suspect. Then the investigation takes place. If the investigation turns out, you know, to yield no wrongdoing or whatever, it's not usually the case that the mandated reporter is going to get in trouble. In fact, it's the opposite.
No, if they make it in good faith,
you're good.
Fine,
you're protected.
Covered.
You know, none of that would exist if the requirement was you had to have proof.
Right. Yeah. And so like, you know, as the attorney, I'm thinking about mandatory reporting, right? Like, is the obligation, because I think we mentioned it earlier, like reasonable suspicion is kind of the trigger, right?
Yeah.
But like for Title IX, we've talked about Title IX prohibitions against sex discrimination, which also covers sexual harassment, and schools can be legally responsible for failing to address sexual harassment that they know about under certain circumstances. And one of the things that they have to have is like what the court calls actual knowledge.
Yes.
Or notice that sexual harassment is happening. And that, that notice, and this is explicit in the new 2020, they're not even the new ones anymore.
Right.
The current Title IX regs, the 2020 regs that the Trump administration has reinstated, you know, they're very clear that knowledge can come from firsthand accounts. It can come from personal experiences, but it can also come from third parties.
Yes.
And so like this idea that you need proof is wrong, right? Like, it's just wrong-headed.
Right.
And, you know, there's obviously line drawing issues here. Like
sure.
There's a difference between I heard it 18th hand as a rumor versus I heard it from the student's very good friend who had multiple conversations with her and asked her permission to tell me.
Right.
And like, you know, this is obviously a line drawing issue, but you know, that line doesn't depend on where the information is coming from.
Is it plausible? Right.
Right. Yeah. Like, does it give you like credible information that sexual harassment might be happening or abuse or neglect might be happening.
Would you be worried that, that this kid is potentially in a bad situation? And if the answer is, yeah, I could be worried about that, then report.
Right. When in doubt, don't do nothing.
Exactly. There it is. So where we left off was Small telling Anthony, I need this information from B herself. Okay?
Right.
So Anthony goes back to class and tells B that Small needs to talk to her.
Okay. And hey, that's not a bad next step.
No, it's not a bad next step, but
it's a bad only step.
It's a bad only step, and it's a bad next step if the reason why you're doing it is because you're not going to do anything until you have that conversation.
Exactly.
Right. But it doesn't hurt to say, I would like to try to talk to this student.
Yeah.
So Small, for her part, either that day or the next day, talked to B's guidance counselor, Mr. Britton. Okay. So like they're probably divided up, by the alphabet or whatever, multiple guidance counselors. And so Small talked to this other guidance counselor about the allegations. And while they talked, Small offered to talk to B herself in case B would be more comfortable talking to her, Small, who was also a woman, rather than Mr. Britton, B's guidance counselor, who was a man. All right?
Totally.
Given the allegations of a sexual nature, that makes perfect sense. And that was apparently the only next step that Small and Britton decided on in that meeting. Yeah. So Britton, importantly, is the only other person that Small talked to about this. Okay.
Okay. So she did not report it.
She didn't. No, I think that was obvious from, the beginning of the episode.
Oh, yeah. Hey, I pay attention. I promise.
Yeah. So Small sent B hall passes, inviting her to come to talk to her in her office on at least 3 occasions.
Okay. But we know that B is worried about like the potential implications coming back to her. And like, she's really nervous about this. And like,
yes,
this is problematic because it's like shifting the obligation to the victim. And like,
right. So Small is still, here, hall pass, right? Come talk to me. So unsurprisingly, B never responded to those hall passes. Okay. Which kind of reinforces the fact that she's not really that comfortable going to talk to somebody about this. At least one of those passes was sent in December of 2014, and 2 more were sent in January 2015. Okay.
Okay. Yeah.
So,
my lawyer brain is.
Yeah. There's the fact that this has gone on for a month, without any sort of reporting, without any additional conversations with anybody,
And B is still in RV's class.
Oh,
right?
Yeah. That's right. Yeah.
Right. And that gets kind of like breezed over by the court. But like in December, B is in RV's class. So when Small hears about this, they're still in class together.
In class. Yeah.
Right. Yeah. So like my head is spinning because like I've got Title IX swimming around in there. I've got mandatory reporter issues swimming around in there.
Yeah.
I've got potential tort liabilities swimming around in there, depending on like when this happened, if it's still ongoing, if like, we've got negligent supervision, negligent hiring, retention, like, I've got so many legal issues swimming around in my head because the response here seems to be so inadequate, right? Because that's what Title IX, like to be. So, the Title IX regs, which I've already mentioned, like they require any employee of a K-12 school to report suspected sex discrimination to the Title IX coordinator.
Now, and that's something that's been a part of the Title IX regs for a while. And remember, like this was happening in 2015, which was 5 years before the 2020 regs came out. But that kind of stuff has existed for a little while,
right?
In the regs
and the like case law about legal liability for Title IX. That's been around for decades now. Especially for teacher to student sexual harassment. Under that, like an appropriate person with authority to discipline the teacher has to have actual knowledge of severe, pervasive, and objectively offensive harassment and respond in a way that is not deliberately indifferent. So like those are our elements, right?
Yes.
And there's this question about like, a lot of those are slam dunks here because you've got severe, pervasive harassment.
Yep.
The response to me is feeling a little bit deliberately indifferent.
Yeah. And it's
because it's not clearly reasonable.
Right. And it's objectively
offensive, right?
Offensive. Like it's sexting with a minor and and
who
nude
is your
pictures
current
and everything.
Student.
Yeah. Like there's really no question that is objectively inappropriate.
Right. And the only question for me, like under the Title IX stuff, is whether or not the guidance counselor is an appropriate person, because guidance counselors typically don't have authority to discipline teachers. So in some sense, they might not be. But this is, again, just for monetary liability under Title IX. It's not related to like these other statutory things. So like we've got Title IX concerns. We've got obviously the mandatory reporter soon. And then, there's so much legal consequence to what this teacher is or is not doing, the guidance counselor is or is not doing right now.
Exactly. So let's see how this all played out. So
I don't know if I want to.
I know. We get through winter break. We end up in the spring semester and things start falling off the rails for B. Okay. Starting to have attendance issues. Something's unraveling here, right? So B's guidance counselor, Mr. Britton, met with B and her mom on multiple occasions to discuss B's attendance issues. Small was present at some of those meetings, not 100% sure why, but she was.
Additional support. Maybe.
Yeah. So at those meetings, they talked about B's declining academic performance. They talked about B's boyfriend, not RV, like she has a boyfriend. And just curious, Chris, do you know what they didn't ever talk about in any of those meetings?
I'm going to guess the allegations brought forward by student A, Anthony.
We have a winner. Yes. Ding, ding, ding.
Yay.
So they didn't talk about any of that stuff. The case goes into some details about what may have been causing B's attendance and academic issues aside from the RV stuff. Okay.
Right.
B turned 18 in January of 2015 and immediately went to go live with her boyfriend at his dad's house. Okay. And B and her boyfriend both frequently skip school. Okay. So part of this is like, B's like, I'm 18. You don't have that same sort of legal control over me anymore, parents. So I'm going to exercise some of my rights as an adult, and I'm going to live with my boyfriend.
Sure.
So when asked about her attendance, B said that she skipped school for multiple reasons, not just because of RV, but also because she hated math class. She was having family issues. Like, she's got a lot going on.
Interestingly, she said it wasn't just because of RV, which means RV was still a reason.
Yeah.
Right.
Absolutely.
So,
right.
Severe, pervasive, and objectively offensive.
Right.
That deprives them of an education opportunity.
Right. And this is the stuff that came out in the case. It didn't come out when she was having conversations with her guidance counselor. When they said, why are you skipping school? She didn't say, well, it's not just all because of RV, because remember, they didn't talk about RV.
Didn't tell them about RV, right?
That came out when they were going through the case. So anyway, due to these attendance issues, B was dropped by the high school in March of 2015. Bye. Okay.
So I assume that means like she didn't have regular enough attendance to continue enrollment, or she dropped out because of non-attendance or something like that.
Yeah, she was as of what we know is as of March 2015, she wasn't at the high school anymore. Okay. So in May of 2015, there pops up this unrelated investigation at the district into potential improper conduct between a student and a paraprofessional, not RV.
Unrelated to RV. Okay.
Unrelated. So there's this other investigation going on at the district that involves inappropriate conduct between a student and a staff member. Okay. And during that investigation, several students informed administrators that RV had been involved in inappropriate relationship with a student, but not B. Okay.
Oh.
Yeah. So like some other investigation is going on, has nothing to do with RV. And in the course of that investigation, there are allegations that pop up against RV, but not with B.
Right. Okay.
So it sounds like we got some major issues here at this school.
Yeah. Something's rotten in the state of Denmark.
Exactly. Illinois. But
I don't think Shakespeare was writing about Illinois.
Well, he was missing out, apparently. He didn't know about this situation. So the district's superintendent told Britton, the counselor, to interview RV about the allegations and asked Small to interview the student, this other student.
Not B.
Not B. Yeah.
Right.
So at this point, Small decides,
there's an allegation against RV. I should probably say something.
Yeah, and it's not against B, but hey, I know another allegation against RV, right?
Right. I've heard rumors about RV.
Yeah, rumors. All right. So anyway, Small tells the superintendent that she had heard rumors about RV.
Okay.
After the interviews had been completed, the school came to the conclusion that the allegations made by the students about RV had been fabricated by 3 students.
Huh.
But during the investigation, those 3 students confided in a teacher that there were other students who may have, in fact, had an inappropriate relationship with RV.
Oh.
Okay.
So these 3 students.
We made this stuff up about these other students, but there's other students.
Right. So it sounds like these 3 students doing what students do were assuming best intentions. We're trying to basically protect the potential victims here,
possibly,
but still highlight that RV was engaged in inappropriate stuff. So like that, that's one potential way to explain the actions here, right?
Yeah, exactly. So all of this led to another investigation. And for this one, the superintendent decided to involve the police department. Okay. All right. Good job, superintendent.
Yeah. When you're dealing with criminal activity, talk to the police.
Exactly.
You are an educator.
That's right. You are outside of your wheelhouse. Okay. So during that investigation of these new allegations, a detective from the police department and an investigator from the state's attorney's office interviewed Anthony. So remember the first kid who reported B's friend.
Right.
Who
Good.
reported
Someone's finally talking to Anthony.
Yeah, exactly. Other than Small. And Anthony told them exactly what he told Small. This time, someone followed up, and during the investigation, RV admitted to sending naked pictures of himself to B and having sexual contact with 2 other students after they had graduated. Okay.
Wow.
Yeah. So now the you-know-what is coming to light and then hitting the proverbial fan.
Uh-huh.
RV also admitted to having sexual contact with a 16-year-old student at the high school, after which he was subsequently, guess what? Arrested,
right?
Yeah. So during this investigation, the police interview a bunch of people, including RV. All of this stuff comes to light. RV admits to all this criminal activity and he gets arrested. And during the course of that investigation, Small was also interviewed, and she confirmed that Anthony had shared all that information with her in December of 2014. Okay, remember, we're like 8 months later than this.
Because what?
At this point,
this is May-ish?
Yeah. So she confirmed all that. And she said, so here's Small's reasoning for not saying anything. She told him she could not act on an unsubstantiated rumor. Okay, now we've talked about all of that stuff, 10 minutes ago. To her credit, a few days after the interview, Small sent an email to the superintendent in which she expressed remorse. Here's what the email said. The email said, quote, "If I had other students come to me with the same rumors, then I would have come to admin with it. But one statement from one student that wasn't backed up at the time by the alleged victim just seems like so little at the time. In a small town, one hears all kinds of rumors. I have heard some pretty ugly things about people. If we pursued every one of those, it would be so ugly and destructive to so many people. In hindsight, this rumor was a smoking gun. I feel truly, deeply horrified by the whole thing. I love my students. I love my job. It is tearing me up that I could have missed something so awful." All of this unquote, all of this stuff is to me, very reasonable feelings to have.
I get it.
After the fact. I totally get it. Okay.
Right.
I totally get it. And listen, when I was reading through these facts, it was never sort of a question in my mind, like, this guidance counselor is a horrible person. Like, that never crossed my mind, right? Like, there was nothing that made me say
malicious here, right?
Yeah. There was nothing that made me say this person does not care about students, and just is more about, this is a person who was confused about what their
made a judgment call, right?
Made a judgment call, was confused about what their responsibilities were, and made a judgment call. And in hindsight, really bad judgment call.
Right. And, we can look with hindsight, right? But when you're making these determinations, you're looking at what you knew at the time.
100%.
You learned about all this stuff. And so I guess there's something there about Anthony having bad blood with RV. Yeah. And this is just one person from a third party. I understand all that. But given the significance of the allegations, that's got to weigh too, right?
So Principal, superintendent, they obviously follow up on all of this. It came out that Small not only had not made any record of her meeting with Anthony, so she didn't document. No, she hasn't. This was before Chalk and Gavel came out, man.
I was going to say, we're dropping all the
Chalk and Gavel one-liners.
Yeah.
So she hadn't documented anything about that meeting with Anthony, other than I think she had a couple of comments written on a Post-it note or something like that, and then couldn't track it down.
Permanent record, yes.
Yes, exactly. Couldn't track it down. So for her part, Small explained that she had made reports in the past to Children's Services based on unsubstantiated rumors, and that Children's Services wouldn't accept those reports. This is according to Small. She mentioned a situation in which a student told her that she thought her friend was being hit by her mother. Neither the student nor Small had witnessed the alleged abuse, and when Small called Children's Services to report it, they told her that they wouldn't take the report because no one had witnessed the abuse, observed signs of abuse, or talked to the alleged victim directly.
Interesting. Okay, so that could explain why Small doesn't want to report this kind of secondhand rumor. Or unsubstantiated rumor, right?
If this is true, then in her mind, she has spoken to Children's Services before, and they have sort of either given directly or implied what their parameters are. And Small probably thought the information that I have does not meet the threshold that Children's Services is looking for.
Right. Though to me, that sounds like a Children's Services problem and not a teacher problem.
Well,
right?
But that's a great point.
The teacher's problem is report it.
Yes.
Children's Services problem is decide what to do with that report.
That is a very important point for all of our listeners to hear right now. Okay. It is not for you to decide as an educator, as a mandated reporter. It is not for you to decide what to report and what not to report because of what Children's Services may or may not do with the information. That's Children's Services problem.
Right.
Okay. So.
Right. Your statutory obligation is not dependent on what they do.
Exactly. So let's fast forward a few months. It's September 15th, 2015 now. Small's fired. Okay. The notice of the firing said that Small, quote, failed to respond appropriately to a report that a teacher was having an inappropriate relationship with a student, and you failed to exercise proper professional responsibility in connection with the matter, unquote. So you're being fired for everything that we talked about. It also stated that Small had reasonable cause to believe that a female student, B, was abused and failed to report the matter to the Department of Children and Family Services pursuant to Section 4 of the Abused and Neglected Child Reporting Act, blah, 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 and district policy. Further, the notice deemed Small's conduct irredeemable. So you can't fix this.
Right. And that's a big piece for the for cause issue when you're trying to discipline or dismiss a tenured teacher. Under Illinois law, I think the conduct basically has to be and further training wouldn't have fixed this, essentially.
Yeah. So basically what they're saying when they say irredeemable is, even if she went through
irremediable.
Irremediable. Yeah.
Irremediable. So, I know. Talk about easy words for us to say. Thank you. Thank you, Illinois.
Yeah. Sorry. That makes more sense now.
Right. Unable to be remediated.
Exactly. So what they're saying is even if we provided more training, that's not going to change the outcome here.
Right.
So in February of 2016, they held an administrative hearing before an impartial hearing officer. Multiple witnesses testified during this hearing. And in May 2016, the hearing officer issued a written recommendation sustaining the district's decision to terminate Small's employment. Okay, so Small had to go through, like we said, she was tenured, went through all of this due process, needed to have a hearing if they were going to fire her, blah, 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 went through everything. And the hearing officer backed it up.
Okay.
So for all the reasons we mentioned. And, she didn't fulfill her obligation as a mandatory reporter. That was in violation of policy, that violated the statutory law, district policy, all that kind of stuff. And validated or backed up the fact that Small's actions were irremediable.
There you go.
Did I get it? Okay.
You got it.
So Small probably disagreed.
She did just get fired.
Yeah. So she got fired. She went through all of her due process. They backed up the district's decision to fire her. And Chris, she decided to
bring a lawsuit.
Hey,
that's the turn. No. It always happens. So Small sought review of her termination in court. So she brought a lawsuit in Illinois State Court challenging her termination, basically arguing that the school board got it wrong, that they didn't have enough to terminate her because she had these tenure protections. She doesn't challenge it on procedural grounds. She challenges the ultimate decision. And surprisingly, at least to me, she wins at the trial court level.
That's the turn, sir.
That's the turn, right? Yeah, like this is why I needed my soapbox.
Yeah.
So
okay, wait.
Yeah.
Let's just reinforce this point for the listeners. So after everything we just said, the court said that the school got it wrong.
In terminating her,
and that she basically, well, they didn't say she got it right, but they said that
the school got it wrong.
The school got it wrong. They didn't have legal justification to terminate her.
That's right.
Boy.
Yes.
Wow.
And the reason the trial court said that is because essentially they said that, this all hinged on whether or not Small's conduct was irremediable. And for the trial court, they're like, oh, well, additional training would have fixed this. So it's not irremediable.
So they're basically saying, listen, if you had done a better job, or if you had provided Small and others with a more clear definition of where the lines are, what to report, what not to report, then
if you want them to report unsubstantiated rumors, then you should
tell them.
Told them that, right? That's pretty much the argument, right?
Interesting.
The school board didn't like that.
Okay.
Because the school board appealed that to the appellate court.
That sounds
reasonable, right?
Yeah.
So the appellate court looks at this and it has to answer kind of two questions. Did the school have just cause to terminate Small? And that all hinges at this point on whether or not she failed in her obligations as a mandatory reporter. And then the second question about like whether or not Small's conduct was irremediable.
Okay.
And one important thing I think it's really, really crucial to highlight is when reviewing these sorts of decisions, courts don't look at it fresh, right? Like they're not substituting their judgment for the judgment of the school district.
Yeah.
Their review is pretty limited. And typically they're looking to see if there was an abuse of discretion on the part of the school board, or if the decision was clearly erroneous.
Okay.
So under Illinois law, that's what they're looking for. They're looking for whether or not the school board's decision was clearly erroneous, meaning that like there's firm conviction that a mistake was made.
Yeah. Yeah.
Right. And so in answering those questions,
I don't see it.
Well, and that's the thing, because spoiler alert, the appellate court also sides with the teacher.
What?
Yeah. And, I have a lot of challenges with that decision, but, they kind of say that the teacher didn't fail in her obligation as a mandatory reporter. And, to come to that conclusion, they look at the context, right? Because the obligation triggers when you've got reasonable cause to believe that a child may be abused or neglected, right? So that's our line.
Yeah.
Reasonable cause to believe.
Yeah.
And the court looks at all the context and says like, look, this was an unsubstantiated rumor from a third party. Child Protective Services had already said, like, we're not going to accept reports based on unsubstantiated rumors. Anthony, student A, had reason not to like RV, so maybe there's a credibility issue. And plus, Small, in her role as guidance counselor, is dealing with rumors all the time, including the original unsubstantiated rumors about RV from the 3 students that then led to the substantiated rumors about RV. So like, there's all of those reasons, according to the court, gave enough doubt that there wasn't reasonable cause here to suspect child abuse at that time, right? All of which I call BS on, because every single one of those arguments is bad.
Yeah. Well, I mean, I would say it's bad in light of the fact that what we know about mandatory reporting is you don't need all of that. And everything that we said earlier about that's child services problem, not yours. Your obligation is, if this is possible, you report it. Now, listen,
right.
I will say this, Chris, like I have been involved in some form or another with allegations that have ended up in child services hands. And I will say that every one of those situations was complex and messy. All right.
100%.
And so I don't want this to sound like, man, we think that this guidance counselor was so off base by, like, how could she not do this? Like you said before, in the moment, dealing with everything. and all of that stuff. These situations are messy, they're complicated, they're nuanced. And so trying to do the right thing, which I am sure this guidance counselor was trying to do, like there's nothing malicious here. Mm-hmm. And everything that we're doing on this show is Monday morning quarterbacking, which is a nice little football reference that,
look at that.
Anyway.
And my critique here is with the court. Like, I think the court's reasoning is just bad.
Yeah, I agree with that. Yes. But anyway, sorry, go ahead.
Right. No, so like, they look at all this and like, for all the reasons we've already kind of explained, like, I don't think that they're looking at this in the right way. I'll highlight one where like they talk about Small dealing with unsubstantiated rumors all the time. Like, just because they're rumors doesn't mean like you don't weigh the credibility of it.
Right.
And I don't see any reason to doubt Anthony's credibility here.
Right.
Like there just doesn't seem to be enough here to say like he had some ulterior motive.
Right.
And then also like those unsubstantiated rumors that about RV that at first turned out not to be true, but then led to some true situations. Like that to me kind of highlights why maybe we should investigate these unsubstantiated rumors. And there's a difference between reporting and investigation, right? Like, to me, like there's enough here that it triggers the obligation to report. It might not be proof, but you don't need proof at that stage, right?
Right.
So, all of that. And then my biggest critique of the court is they're substituting their own judgment for the school boards, right?
Yeah,
like,
exactly.
It's not clearly erroneous because here I am, a reasonable person, thinking the school got it right. So like, I think I'm Jamie, am I a reasonable person? but that's room for like disagreement there. And it's not a clear error. So like, I think that because there's no clear error there, like the court, one, got it wrong. And two, got it wrong by reversing the school board when they shouldn't have, because the court here is so far removed from the evidence and the parties and like all of the credibility determinations that you have to make when you're weighing evidence. Like it feels inappropriate for them to second guess in this way when reasonable minds could come to different conclusions.
Yeah, I agree.
And so like the court basically says like, well, district policy follows the mandatory reporting statute. So because she didn't violate the mandatory reporting statute, she also didn't violate district policy. So that's not a good enough reason either to dismiss her for these actions. And then they look at this question of like whether or not it was irremediable. And they basically say like, this is a line drawing issue. More training could have helped. It could have helped Small figure out where to draw that line. And because we didn't find this to be a violation of the mandatory reporting law, Small's conduct wasn't criminal. If she had violated the mandatory reporting law, that could have been criminal. And that would by kind of definition be irredeemable or irremediable.
I know.
I did it too. So because of that, like the court said that Small didn't violate the mandatory reporting statute. Her conduct was remediable. And so therefore the decision to dismiss her should be reversed.
Okay.
And so the court was wrong the board was wrong according to the court for firing Small.
Wow, dude.
Yeah. Now this was a 3-judge panel. So there were 3 judges, 2 of whom joined the majority opinion, 1 who filed a dissent that would have upheld the termination. So I guess there's that. The dissent emphasized like all of the things that we kind of talked about.
Yeah.
Like, there was enough here to trigger the duty to report.
Mm-hmm.
Plus, we should have deferred to the school since their decision was not clearly erroneous. And they also said that like the school provided a lot of training on mandatory reporters and Small still did what she did. So like more training here might not have had any benefit.
Well,
because she'd already gotten the training.
Here's what I would say.
What would you say, Jamie?
Well, I'll tell you, Chris. So, like, you and I come across these kinds of comments all the time, that the law is such a scary thing to educators, especially teachers. And one of the reasons is because they don't get any detail about it. They get very little training. They get very little exposure to legal issues in education. There are only a handful of undergraduate teacher prep programs in this country that cover legal issues in education.
That even require a school law course or anything like that.
Exactly. And, we hear it over and over again in our classes that we teach of, graduate students who are looking to become administrators. So most of these folks are currently teaching. The number of times over the years that I have heard these experienced teachers say, oh man, what I wouldn't have given for this information when I started my career as a teacher.
Right.
It's stuff like that that makes me look at a case like this and say, you know what? Maybe we aren't doing enough to ensure that everybody who works with kids knows enough about what they need to know about.
Right.
Right.
Something so fundamental like the mandatory reporting law. Right?
I mean, it doesn't get much more fundamental than that. You know, what do you do if a kid is potentially being abused? Like, everybody who works with kids should be very clear on what their obligations are, even if the situations are awfully complex and emotional and whatever. At the very least, you should feel like I have to say something to somebody about this, even though I might not know if this warrants a call to DFACS. I'm going to my administrator. Right.
And that's why like the don't do nothing is such a powerful lesson, I think, because we've talked about like the law, like educators see the law sometimes as this slouching beast, like ready to catch them unaware. Right. And it's because there's ambiguity in the law. There's so many legal requirements you have to be aware of. And like that can lead to paralysis. Right. And that's such a natural, completely natural reaction. But it's also like probably one of the most problematic reactions.
Mm-hmm.
And so like, you know, you can think about how this situation would have gone so differently if a different decision had been made, given the constellation of legal concerns that we talked about, right? Like Title IX, mandatory reporting, torts. You got to imagine like it could have come out differently, even though, you know, the school apparently, according to this Illinois court, like shouldn't have terminated Small for what happened.
Yeah. I mean, the big takeaway here for me is not whether or not the termination should have happened. The big takeaway here is, you know, listen to the fact pattern of this case and use that to help guide you to make the right decision. You know, it's not a question of fearing getting fired or whatever. Make the right decision for the kids. All right.
Mm-hmm.
And so, you know, the court ruling, even though that's a weird, questionable one, at least as far as we're concerned, is not the big takeaway. Right? The big takeaway here is your obligations under your state's mandatory reporting laws, which are all pretty similar. If you suspect, you don't have to have proof. If you have information,
it doesn't have to be firsthand.
It doesn't have to be firsthand. If you have information that something inappropriate, criminal, abusive, whatever is going on, you pick up the phone.
Mm-hmm.
Okay. Or at the very least, you speak to your supervisor, your administrator or whatever. They may have a much more, they've taken a school law course theoretically. They might be more comfortable or understanding of where those lines are, and they will help you make the decision about calling. Here's the other thing to report, and I would love to hear your take on this, Chris. Like, let's say, hypothetically, similar situation, you go to your administrator.
Hypothetical.
Yeah, here we go. Similar situation, you go to your administrator and you say, I don't know if I should call child services about this one. And the administrator says, no, we're not going to call. If you are left uncomfortable with that, what do you think about a situation like that, Chris?
So it depends. It's going to depend on state law. Some states have said that merely reporting it up the chain of command does not relieve you, the teacher, of your obligation to report.
Right. But others say that's enough.
Others, it depends on the state. So, but like, you know, you can get advice, but like, be very careful because, you know, you're the person who has the suspicion. And so like, that's going to be your obligation, depending on the state law. So like, you know, it's one of those things where like, this is one where the consequences of getting it wrong are so significant that like the balance is when in doubt, report.
Right. And so here's what I would say to administrators. This is what I would say to everybody. Know your law, know your state law, know your district policies.
We're busting out all the chalk and gavelisms.
Exactly. This case has it all.
Next, you're going to talk about relationships and like the value of good community relationships.
We got to draw the line somewhere today. So, but you know, advice that I would give to an administrator is obviously know your law. But if your law, for example, is that kicking it up the chain of command is enough, tell that to your teachers. If your law is, and then just know that responsibility is on you. Okay? Because If somebody kicks it up to you, then now you are burdened with that responsibility, right?
Right.
Now, the flip side is if your state law is kicking it up the chain of command is not enough, doesn't relieve the person with the information of their obligation to report, also tell the teachers that, okay? And say, listen, this is what our state law says. I am happy to help you try to navigate the situation. I'm happy to make the call for you. I'm happy to whatever. But if I say, I don't think this rises to a reportable thing, you just need to know that that responsibility still falls on you. And as an administrator, if it were me, I would say, and I will back you up. Even if I say, I don't think this rises to that level and you still want to report it, I will not hold that against you. Right. I understand that this is the law and that responsibility is yours. Mm-hmm. And so if you do choose to report, I got your back, right?
I think this thought experiment kind of highlights there's two things happening here. One is the Child Protective Services stuff, which is outside of school. And the other is the inside of school stuff, which is hey, there's a thing going on right now with our teachers
and how do we
our
deal
students.
With that? Yeah.
How do we deal with that?
Yeah.
I can't deal with that if I don't know about it.
Exactly. No, these things are highly complex, and we've mostly just touched on the mandatory reporting pieces and not all of the other complexities that often surround these issues and how it plays out in schools. But anyway, hopefully, folks, this has given you some food for thought.
I think so.
Yeah, thank you for picking this case, Chris. This was a great case.
Yeah, I almost didn't do it because I was so opposed to what the court decided. But I was like, you know what? There's some good lessons in here.
There's great lessons.
I'll just get angry.
That's right. Well, don't put that soapbox away, sir. I'm sure we're going to need it soon enough.
I will keep it handy.
All right. So what's our homework today?
Your homework, since we're busting out the chalk and gavel isms, is to not do nothing. So go ahead and do something by finding Chalk and Gavel wherever you get podcasts, rate, review, subscribe. You can leave us reviews. That's actually a super helpful way for us to jump the algorithms, if you were. Tell a friend, tell a colleague, tell a neighbor, tell someone you're stuck in traffic with. It doesn't matter to me. Just spread the word about Chalk and Gavel. You can find us on social media at Chalk and Gavel. You can email us at chalkandgavel.com. We've got our feedback form on our website, chalkandgavel.com.
Hey, roll down your window. I'm listening to this great podcast. You should check it out.
Hey, okay, viral marketing, right?
Man. All right, folks. That does it for us on another episode of Chalk and Gavel. We will see you back here in 2 weeks. Have a good one, everybody.